Any views, thoughts, and opinions expressed by the journalist and guests are solely that of the journalist and guest and do not reflect the views, opinion, policies, or positions of Positive Lifestyle Management.
Greetings, brothers and sisters, men and women all around the world. Welcome to another episode of PLM News. I'm your brother Fiji, and we back. Yeah, we took a little hiatus, been doing a lot of work, and putting some things together for the audience. It's 8:27 in the morning, a.m. Let's get to this here. I received a call a few days ago, and that call was, they asked me, was all proffer statements snitch statements? And I said, no, not all proffer statements are snitch statements. Not all proffer statement includes other people's or concern other people's, So, no, not all proffer statements. I No, I gave my expertise in it from what I know about proffers and the law and all that. So I didn't think nothing else about it. This morning, I wake up, I get some legal documents. And in these particular legal documents, it concerns a profit statement. Hold on for a minute. This is not the right platform for this one here. Hold on for a minute. I'll be right back.
Snitches and rats are not the same thing. Let me break it down, make sure y'all see what I mean. A snitch is someone minding other folks' business to find information they can sell for a price or trade for some other form of compensation. A rat is a trader, a conceiver, planner, or physical participator. He doesn't sell secrets for power, for cash. He betrays the trust of his team or his family, hoping to save his cowardly ass. The difference is, at least a snitch is human, but a rat is a fucking rat, period.
The Rat Saga is back. Mm. And the next rat on the list, mm, 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 is Mr. James Highsmith. Highsmith. The legendary James Highsmith. Let's ask ourselves, how did you get on this list, Mr. Highsmith, when all your life, your claim to fame was you shot Larry Hoover? You was known in the community as an upstanding man. Back in the day, your name reigned as a legend a Chi-Town legend, as they call, what is it called, Street Legends of Chicago. You was a street legend. But what we have today is totally opposite of what you allegedly stood for. Now, this is what, as I was saying, I received a call. I was asked about the proffer statement. I explained to them that not all proffer statements has to deal with snitching or telling on somebody. I woke up this morning, like I said a few minutes ago, it was 8:27. I woke up, checked the emails, bam, I get these documents. And in these documents, it's Mr. Highsmith doing his thing. If we don't know, we definitely gonna find out today. The memorandum in order coming from the judge. We're gonna go down to the next paragraph. It all started out by, first of all, I ain't gonna jump ahead. I got to do this in order so that people can understand what we are dealing with here. And what we are dealing with here is Mr. Highsmith proffer. Is he telling something? That's what we are dealing with. That's what we are dealing with. So the first thing we got to do, y'all got to have patience. You got to have patience with this one here, because I'm going to take you through steps, stages, and degrees so that you can understand what this is about. So the first thing that we're going to do, we're going to break down what a proffer statement is. We're going to break that down. Let's break this proffer statement down first. All right. We're going to use the U.S. legal on what a proffer statement is. And we're going to go down proffer agreements, law, and legal definition of a proffer statement. It says, in the context of criminal law, a proffer agreement is a written agreement between federal prosecutors and individuals under criminal investigation which permit these individuals to give the government information about crimes with some prosecution. Witnesses, subjects, or target of a federal investigation are usually part of such agreement. Proffer agreements are not complete immunity agreements. Although the government cannot use an actual proffer session statement against the individual in its case in chief, the information provided can be used to follow up leads and conduct further investigation. If those leads and further investigations lead to new evidence, the new evidence can be used to indict and convict the individual who gave the information in the proffer session. All right. Back to the case. Highsmith. The relevant facts of this case is, after considering all of the materials before us, the court said, we conclude that Highsmith is not entitled to relief under 2255, which is a habeas corpus, which is a post-conviction petition in for better words. That's all it is, a post-conviction petition. Because his claims relates to the execution of his sentence, not its imposition. The execution of a sentence is how you serve the sentence. The imposition of the sentence is how the sentence was given to you. Was the sentence given to you illegally? Did the government or the judge or somebody violate your constitutional right? Or was the sentence imposed against you wrong? But the execution of your sentence is how your sentence is being served. That's the difference. The execution is how the sentence is served. The imposition is how the sentence was given to you. So he was talking about how his sentence was served, not how the sentence was actually given to him, but how he was serving the sentence. That's the difference. All right. So now we understand the difference between the execution of a sentence and the imposition of a sentence. Now, they say the relevant facts are as follows. Highsmith was arrested on drug charges in July of 1992. In August of that year, he and his then attorney, Charles Murphy, met with Assistant United States Attorney Scott Levine and two federal agents in order to provide a proffer that detailed his involvement in narcotics trafficking, named several of his associates in the drug trade, and provided other information as well. Let's get that understood. Now we're going to go back down here and I want y'all to understand what I said. He met with Charles Murphy. Him and his attorney, Charles Murphy, met with Assistant United States Attorney Scott Levine and two federal agents in order to provide a proffer that detailed his involvement in narcotics trafficking. He named several of his associates in the drug trade and provided other information as well. Off the door, off the muscle, anybody that has ever been inside Federal Bureau of Prison, you know, if you name your associates or somebody else that's involved in the crime with you, you tell it. That's anywhere throughout the land, whether it's feds or state, you tell it. If you're giving up other information on somebody else, you tell it. All right. Let's go on. Highsmith's attorney made it clear to the government that Highsmith would provide the proffer, but that he did not want to fully cooperate with any ongoing investigation of other suspected drug dealers, even though such cooperations could earn Highsmith a downward departure in his own sentence should he choose to plead guilty. Now, his attorney said this here now. That's what his attorney made it clear. But he sat down with him to provide information. All right. But let's keep moving. We're going to get to the bottom of this today. We're going to get to the bottom of this. In July of 1993, Highsmith pleaded guilty to one count of conspiracy to possess cocaine with intent to distribute and one count of possession of cocaine with intent to distribute, which together carried a maximum sentence to life in prison. In exchange for his plea agreement, the government recommended that Highsmith be sentenced at the lower end of the applicable sentencing guideline range, which required a minimum of 120 months imprisonment. That's the minimum. At the sentencing hearing, Highsmith attorney requested a sidebar during which AUSA Levine informed the court that Highsmith's plea agreement reflected that he was cooperating with the government. Check this out now. Check this out. It says that Highsmith's attorney requested a sidebar during which AUSA Levine informed the court that Highsmith's plea agreement reflected that he was cooperating with the government, but that such cooperation did not rise to the level of substantial assistance, warranting a downward departure in Highsmith's sentence. In January of 1994, we sentenced Highsmith to 170 months in prison. That he did cooperate, but that his level of cooperation did not rise to the level of getting a downward departure. So he did sit down and tell, but he did not tell enough. He told, damn, man, but you did not tell enough. When are you all going to learn that the government does not care about you? Case in point, watch this. Between 1995 and 1997, the government prosecuted various members of the Chicago gang known as the Black Gangster Disciples for drug trafficking and other unlawful activities. As part of its responsibility under Brady versus Maryland and Giglio versus United States, the government turned over a copy of Highsmith proffer agreement to the attorney representing one of the BGD defendants. At some point in 1997 or 1998, Highsmith heard from various sources that he and his family were in danger because the BGD believed that he had cooperated with the government by providing it with information about the gang. In 1995, Highsmith's new attorney spoke to a BGD attorney who confirmed that the government had turned over Highsmith proffer. Then it did footnote 2. You go down at the bottom with footnote 2, it said the government does not deny this charge. Indeed, it produced a copy of the letter accompanying the Giglio material it turned over to the defendant's attorney in United States versus Eric Wilson, 95 CR 509-6, which included Highsmith proffer. Now, we get to the gist of Highsmith's argument is that the government induced him to plead guilty by assuring him that his proffer would remain confidential. So Highsmith was trying to tell in secret. He was trying to tell in secret that this is how this goes. If none of those individuals would have went to trial, if nobody would have went to trial in that case in 1995, Highsmith proffer would have remained silent because there would have been no obligation under Brady versus Maryland and the Giglio for the prosecutors to turn over the material because it wouldn't have been Brady material if nobody would have went to trial. But peoples went to trial. And when they went to trial, they requested all of the Brady material. And as a part of the law under Brady versus Maryland, the prosecutors has to turn over all of the material. They have to turn the material over. All statements and everything that's against them. So that way they can prepare a defense against the charges being lodged against them. All right. He said that when the government breached that promise, it created a danger to Highsmith that violated his due process rights under Monfrel versus Taylor. Police created a danger to descendants and violated his due process rights when they released a tape containing his anonymous tip after specifically agreeing not to do so, resulting in plaintiff's death. All right. Here's the issue, though. Did the prosecutors promise Highsmith that they wouldn't turn over the proffer statements? If they promised him that, and these men and women went to trial and they held back the Brady material, that would have been a Brady violation. If they held back that material from them, knowing that this was part of the case, that would have been a Brady violation. Highsmith, get back to the case now. Right here. Highsmith knew he would probably receive a longer sentence if he did not provide substantial assistance to the government. But cooperating would put him and his family in danger of harm from the BGD. That is, Highsmith knowingly accepted a longer sentence in exchange for the government's promise that it would not disclose its profit. That's his argument. This is his argument. Highsmith contends that when the government released his proffer to the BGD, it treated him as if he was a cooperating witness. So now he should at least receive the benefits of a downward departure in his sentence. Guideline Manual 5K1.1, November 1998. That's when the guideline come out. Okay, we want to do it right. It say the Federal Sentencing Guideline Manual, Chapter 5, determining the sentence, Part K, departures. Substantial assistance to authority. 5K1.1, substantial assistance to authority. Policy statement. It says, upon motion of the government stating that the defendant has provided substantial assistance in the investigation or prosecution of another person who has committed an offense, the court may depart from the guidelines. A, the appropriate reduction shall be determined by the court for reasons stated that may include but are not limited to consideration of the following. 1, the court's evaluation of the significance and usefulness of the defendant's assistance, taking into consideration the government's evaluation of the assistance rendered. 2, the truthfulness, completeness, and reliability of any information or testimony provided by the defendant. 3, the nature and extent of the defendant's assistance. 4, any injury suffered or any danger or risk of injury to the defendant or his family resulting from his assistance. 5, the timeliness of the defendant's assistance. So Highsmith was trying to go up under number 4. Any injury suffered or any danger or risk of injury to the defendant or his family resulting from his assistance. So Highsmith said, okay, since y'all violated my profit and y'all told me that y'all were going to keep this confidence when the government, we ain't got to that part yet. We're going to find out if the government agreed to that y'all placed me and my family in harm's way. So if y'all place me and my family in harm's way, I should get the benefits of a downward departure up on the 5K1.1, which is the snitch motion that comes from the government. This is what I've read so far. Y'all are reading along with me with this here. I'm keeping this up so that you all can see what's going on with it. All right. Now watch this. The bottom paragraph. It says, the government claimed that it never, not at the time the proffer was made, nor during Highsmith plea agreement, promised Highsmith or his attorney that the proffered agreement would remain confidential. Let me read that again so that y'all can understand what's going on. The government claims that it never, not at the time the proffer was made, nor during Highsmith plea agreement, promised Highsmith or his attorney that the proffer agreement would remain confidential. The government says it only promised that if Highsmith plead guilty, it would recommend sentencing him at the lower end of the applicable sentencing guideline range, which they did. They sentenced him. That's what they said they did. That's what they said they did. They sentenced him down. They ain't give him but what 13, 14 years. That's all he got. Highsmith does not dispute that the government adhered to this part of the bargain and agrees that his sentence would be correct, but for his belief that he is now entitled to a downward departure for substantial assistance. He's arguing the execution of the sentence, not the imposition of the sentence. He agrees that the imposition of the sentence is correct. He's agreeing that the government never breached this agreement with him. He's agreeing to all that, but he's saying, "Hey man, due to the fact that I received some information that me and my family are in danger of getting injured because I made a proffer, then up under 5K1 number 4 that I should get a downward departure." This is what the court said. It said, as we explained in our earlier order, Highsmith might be entitled to Hague relief if the government breached any promise it made in order to induce Highsmith to plead guilty, since this issue would be directly related to the imposition of his sentence. Holy, 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 holy moly. Holy moly. Exactly what I've been telling y'all. This is exactly what I'm telling you. If they would have breached any part of that agreement with him, that's the imposition of the sentence. He's not arguing the imposition of the sentence because he's saying that, okay, the government did that. They did whatever they said they was going to do for me. I'm saying since my snitch motion or my snitch statement got out, that, hey, now y'all should give me something for that because y'all done put my life in danger. That's what he's saying. That's what Highsmith is saying. And this the same man now that back in the day, he went up into high school, him and Leonard Longstreet, and shot Larry Hoover and 2 or 3 other people. Shot him. So he'd been living off that claim to fame all these years that he shot Larry Hoover. It's all you got to do. All you have to do is Google it. If y'all think I'm lying to you, go Google his name. You know what's going to pop up? The man who shot Larry Hoover and lived to tell about it. And that's what he's been doing his whole life since then, telling about how he shot Larry Hoover. But since you telling this story about how you shot Larry Hoover, why don't you tell the complete story? Tell the story on how in 1992, when you got bumped, you gave up information on Larry Hoover and everybody else that was involved in that case. Or I ain't gonna say everybody else, but some more people that were involved in that case. And mind you now, this was 3 years before they was indicted, because you went and sat down with these peoples in August of 1992. You got bumped in July of 92. You went and sat down with them in August of 92. They wasn't indicted until August of 1995. That's 3 years. So 3 years prior to them being indicted, you had already sit down and gave up information on them. Come on now, make it make sense. And I told y'all in previous episodes of the Rat Saga that there's people that's part of these violent prevention organizations that are working with the government. Because once you start working with the government, then you're going to continue working with the government, man. You become a harlot. Once you get into bed with them, you're going to always be in the bed with the government. And I told y'all, I told you. But see, y'all think I be on here just pulling y'all leg and I'm just out here playing a game with y'all, man. I'm telling y'all, man, there are agent provocateurs everywhere. They everywhere. How can I co-sign an old snitch that was gang banging back when Jaws was a goldfish? This is what Lloyd Banks said. He said, how I can't co-sign an old snitch that was gang banging when Jaws was a goldfish. This is an old snitch, man. Do the old snitch. Straight up. Straight up, man. That dude was snitching in 1992, man. You know where I was at in 1992? Serving 30 years in prison after going to trial. And some snitches got on the stand on me. That's where I was at. And you know what he was doing in 1992, in August of 1992? Sitting down with the government against other men and women. That's what he was doing. So, as I said, with this man, but a rat is a rat. That's what he is. He's a rat. And I dropped the mic on that one now. You all have a good day. Mic drop.